Hi, I'm Kathi Sandweiss. I'm an appellate lawyer here at Jaburg and Wilk. You can appeal an order from bankruptcy court just like you can appeal an order from a civil court, from Superior Court. There's certainly some differences that are really important. Perhaps the main one is the very short time period for appeal. The kinds of things that are appealed from a bankruptcy court will typically involve whether or not someone was granted a discharge. And as you can imagine, to the debtor is going to want a discharge. The creditor is going to want a denial of discharge. And so that's typically a very adversarial issue. It'll come up in an adversary proceeding, and then it will typically be appealed by one side or the other. Well, you file your notice of appeal with the bankruptcy court, but then there's a determination that needs to be made as to whether you want your appeal to be heard by the district court or by the bankruptcy appellate panel, the BAP. And so another big difference between a civil appeal and a bankruptcy appeal is that there's this sort of intermediate level of appeal, which would be before you would get to the Ninth Circuit. So one of the determinations that we make when we're considering your bankruptcy appeal is whether we want a district court judge who may not have as much experience in bankruptcy to hear your appeal, or whether we want to go to BAP, where it's all bankruptcy judges and they do definitely have lots of experience in bankruptcy. We'll make every effort to consult with your bankruptcy lawyer. We love to have the trial lawyer or the bankruptcy lawyer read the briefs, give us their input before the briefs are filed. And then if we're representing the appellant and our goal is to have the matter reversed and remanded to the bankruptcy court, your bankruptcy lawyer then will take the case over again once you get back to the bankruptcy court.